Stays of Removal, New York City Practice. Thank you for joining us for a quick training on stays of deportation and removal. This training is not intended to be exhaustive. For your client's case, please review the other references we provided and contact your Her Justice mentor regarding specific questions that may come up. What is a stay of removal? An I-246 application for stay of deportation or removal asks the Immigration and Customs Enforcement Agency Enforcement and Removal Operations, ICE ERO, to use their discretion and delay carrying out a removal against a person for up to 2 years. This is generally used where a person has relief for which they have applied or are in the process of applying for. In our cases, this usually means a pending petition for non-immigrant status or a VAWA petition. If the stay is granted, removal of the applicant is postponed and the applicant will have to check in at a later date with ICE ERO. Most stays are granted for a year or less, and the applicant can apply for a further stay of removal at the expiration of the original grant. A stay of removal will result in an order of supervision, allowing your client to apply for employment authorization per category C18. In short, an approved application for stay of removal temporarily stops a person's removal from the United States, allowing time to wait on USCIS's adjudication of their petition or application for immigration relief. Now on to the who and why. Who needs a stay of removal? But first, let's go through some acronyms, or shorthand. The applicant is the person who has the unexecuted removal order. ICRO, Immigration and Customs Enforcement, Enforcement and Removal Operations. The IJ, Immigration Judge. OSUP, Order of Supervision. USCIS is U.S. Citizenship and Immigration Services. Many clients for whom we complete consultations and are eligible for immigration relief, think about a VAWA petition or a U visa, have unexecuted final orders of removal. This means that they were ordered removed or deported in immigration court, but the IJ delayed removal or the order of removal was in absentia, and this means that the applicant never appeared in court. Many times, the removal order was issued years ago and the government never carried out the removal. To apply for a stay of removal or deportation, the applicant must be in custody of Immigration and Customs Enforcement. Custody for our purposes is either 1, being non-detained and required to check in regularly with ICRO on an order of supervision or some other arrangement, or 2, being actually detained by ICRO in a detention center and facing imminent removal. The when, how, and where. When. So first, it's important to understand what stage of removal proceedings the applicant is at. If your client, the applicant, is in removal proceedings, actually attending immigration court, and they do not have an order of removal, the stay application is not for them and not necessary. However, if it is post-removal proceedings and there is a final order of removal entered against your client, have your client immediately sign what we'll call a pocket stay in case of arrest by ICE. If the applicant has a final order of removal and is in a version of ICRO custody, an OSUP or order of supervision, and they check in regularly with ICE, you should prepare and file a stay of removal application before the applicant's next scheduled check-in. If the applicant has a current stay of removal which expires soon, go ahead and prepare and file the stay of removal application to renew their stay of removal. Best practice in general is to file a stay of removal application at least 30 days before the applicant's ICE ERO check-in date. The how and the where. Go ahead and Google ICE Form I-246 and make sure you are using the most current edition of Form I-246. To check this, look at the form instructions to see the most current date and then see the bottom left-hand corner of the form to compare. Now there's 2 formats. I had mentioned the pocket stay before, and this is what you do for a client where you're worried about them being picked up immediately by ICE. Have one ready to go for any client who has an unexecuted final order of removal. This is a skeletal application to have on hand in case of ICE enforcement. At a minimum, have your client sign a Form G28, Notice of Entry of Appearance as Attorney, and a Form I-246, Application for Stay of Deportation or Removal. Also record the name and contact information for a friend or family member of the applicant who can get you a money order or cashier's check made out to the Department of Homeland Security or Immigration and Customs Enforcement for $155 in the event of an emergency in which your client cannot get you that money order or cashier's check. As supplementary material, also compile as many of the following documents: USCIS receipt notices, a draft of your to-be filed application, or even if all you have is a signed U visa certification, include a copy of that. ICE issued documents, including an OSUP or other check-in documents, documents regarding arrests or convictions, any discretionary evidence pertaining to good moral character, family ties to the United States, tax returns filed, education history or ongoing education, or community service. Also include ICE memos, which are included in your materials, the ICE Victim Witness Prosecutorial Discretion Memo from 2011, and the ICE guidance relating to stays of removal. Now, if you have the time where your client checks in regularly with ICE, you would want to put together a complete I-246 application. The first thing would be a cover letter containing your legal argument. The $155 fee would come second, obviously in the form of a money order or cashier's check. The instructions indicate that cash is accepted, but we have never seen ICE to actually accept cash. You would want the Form G28, Notice of Entry of Appearance as Attorney, Form I-246, the application for the stay of removal, your applicant's statement. Again, a lot of what I talked about before, the USCIS receipt or action notices, drafts of applications, or the U visa certification, the applicant's birth certificate and translated if necessary, along with birth certificates of all family members, particularly those in the United States. A very important point to remember is you must have the applicant's original current passport if ICRO does not already have it. ICRO used to accept stay applications without being in possession of the applicant's original current passport, but this is no longer the practice in New York. ICRO might already have the passport due to prior check-ins or enforcement actions, but make sure your client gets the current original passport if they want to file the stay of removal application. Again, documents regarding any arrests or convictions, and other supporting discretionary evidence like I had mentioned before. So you want to think about good moral character, or how you can show hardship to the applicant, to your client, or to their close family. Evidence of rehabilitation if your applicant has a criminal history, family ties in the U.S., country conditions in the applicant's home country. So think about the same standard as asylum. So show danger to the applicant and family if the applicant and or family are removed. Tax returns if the applicant worked with USCIS authorization. And again, the ICE memos that I mentioned before, the ICE Victim Witness Prosecutorial Discretion Memo from 2011, and the ICE guidance relating to stays of removal. The where do you go to file this? Go to 26 Federal Plaza in Tribeca. It's around the 300 block of Broadway. Enter the building on the Worth Street side. The original Broadway entrance is closed right now. After passing through security, take the elevator to the 9th floor and go to room 9-901, ICE ERO. Approach the window in the back of the room and present the order of supervision or other ICE check-in document that you have, and present the stay of removal application, informing the ICE officer that you would like to file your client's stay of removal application at that time. The ICE officer should take the application, take the client's or applicant's original passport if they don't already have it, if ICE doesn't have it in their possession, and stamp your copy of the stay application as received on the date that you're there. And then you take your stamped copy to the cashier room to pay the $155 fee. After ICE receipts in the fee, they should provide you with a receipt for payment and stamp your application copy as paid. After the stay of removal application is filed, the ICE officer will usually just provide a new date for the applicant to check in. The date will be 3 or 6 or maybe 12 months in the future. The officer might also want to take a few minutes to discuss the contents of the stay application with you. If the stay of removal application is based on a pending U visa petition, ICE must contact local ICE counsel to ask them to request a prima facie decision from USCIS Vermont Service Center. Any removal of the applicant is stayed for 5 days while the USCIS prima facie decision is made. So, 2 possibilities with the stay application: approval or denial. Now, this is the setting for an approval. If USCIS grants prima facie approval of the U petition and gives U deferred action to the applicant, and ICE approves the stay application. The applicant will receive 180 days of immediate stay of removal. If the stay is approved, ICRO will contact you by mail and let you know the date and time for the applicant to come to ICRO to complete the OSUP, or Order of Supervision paperwork, if they don't already have that on file. You should mark your calendar for 30 days before the stay expiration to note when the applicant's stay of removal renewal application should be filed. If there is no final decision on the pending I-918 during those 180 days of the initial stay, and no new adverse factors arise for the applicant, ICE should extend the stay as needed for USCIS to make a final decision on the 918. Generally, ICRO Field Office Director should work with CIS for a swift decision. We had a recent case where this worked as I'm describing it. It was in the middle of the country, it wasn't in New York, but the client received U deferred action in about a year after filing her I-918, which is a lot faster than the current processing times of 3 years, give or take. If the stay of removal is approved and no U deferred action has yet been granted, the applicant can apply for employment authorization on C-18, or final order of deportation. Now, if the stay application is denied, ICE must provide a summary of the reasons for denial to their headquarters. You could contact USCIS Vermont Service Center through their customer service email address for U visas and request that they expedite the U visa petition, or 918. Other options include getting relevant congresspersons involved, cultivating grassroots support, utilizing media coverage, and considering sanctuary church possibilities. It is important to emphasize at the end of this training that ICRO's decisions on these stay of removal applications are discretionary, and we have heard recent cases of these applications being denied.